Good morning, good afternoon, and good evening. Thank you so much for joining us again. Professor Dr. Luis Maria Palma, President of the International Association for Court Administration. We are developing today the second session of the online conference program jointly organized by IACA with the State Judicial Administration of Ukraine, the EU project Pravo-Justice, and USAID Justice for All activity. Today's conference is dedicated to court safety and security planning in Ukraine. I'll briefly describe the rules for the session. The online conference will be recorded. I'll introduce each speaker before the presentation. After all the presentations, there will be approximately 15 minutes for questions and answers. We'd appreciate if you could send us your questions using the chat box and identify the speaker to which they are addressed. We kindly request you to mute your microphones. The first topic will be the impact of Russia's aggression upon court premises and court operations, conscription of judicial institutions' employees. We'll start listening to Mr. Alexis Salnikov, who regrettably is not present because of urgent official duties, wasn't able to make it. So we'll have the benefit of the participation as a speaker of Mr. Maxim Pampura, Deputy Head of the State Judicial Administration of Ukraine. Please, Mr. Pampura.
Dr. Palma, I think that...
Доброго дня, шановні колеги, шановні учасники заходу. Перш за все...
Dear colleagues, dear participants to the events, welcome. In the first place, let me express my appreciation to our co-organizers, EU project Pravo-Justice, USAID program, and International Association for Court Administration. Pravo-Justice and USAID are our long-term partners who have been providing us with assistance and support for many years, and we are especially grateful for their support in these difficult times. I'm also grateful to all the participants to the conference. Thank you for being here. And on behalf of Mr. Alexis Salnikov, head of State Judicial Administration of Ukraine, I would want to apologize on his behalf. He could not make it for today's event, unfortunately, so he sent his warmest greetings. And now let us see the video which was prepared by the State Judicial Administration on the occasion of today's event.
Дякую за перегляд. Ну, цим, хоч ми і живемо щодня в умовах війни.
Thank you for demonstrating this video. Despite the fact that we all live in the war conditions, despite all the challenges we face every day, starting from the first day of Russian aggression against Ukraine, we continue perform our duty, and Ukrainian courts resume operation. I will now demonstrate the presentation that was supposed to be made by the head of the state judicial administration. I will do that in his place. So the 24th of February was the day that changed our lives, and now we have before and after. Our country was attacked on the 24th of February 2022. It suffers terrible damages all over, across the country. Many objects are being under attack, are being damaged, starting from critical infrastructure and up to residential buildings. As a result of bombardments and shellings, we have 13 court buildings that were completely destroyed. The history about around each court which was destroyed deserves to be told, and this is what we will definitely do after the war is over. Many court premises were damaged, unfortunately, and this is also what we want to tell about, and hopefully we will be able to do that with the help of the Pravo-Justice project. We are planning to make a respective publication. And now let us move forward. I would like to touch upon some particular situation and to talk about some particular court buildings which unfortunately were destroyed during this war. On the 6th of March 2022, the premises of Kharkiv Appellate Court was destroyed by the missile strike. That was a historical building which was built back between 1899 and 1902. What is interesting and particular about this building is that it was built to be a court. It was built for the purposes of administration of justice, which is not the case for many courts in Ukraine. Many Ukrainian courts are located in premises which were initially intended for other purposes, former schools, former non-residential buildings intended for other purposes, but not for administration of justice. While the building you can see in the picture was intended to be a court. It was a huge building at that time, and it was the area was the building constituted 1.57 fathoms. that was huge for that time. The building was heavily damaged during World War II. You can see how it looked like in 1943 at the bottom of the page. The building was renovated with preservation of initial design. It so happened that at the beginning of 2022, the historical renovation of that building was completed. So the renovation was intended to be completed several years ago, but because of the lack of funding, because of some other constraints, it was protracted, and it was completed only in 2022, in the beginning of 2022. The building was completely refurbished, not only from outside, but also from inside the premises. The interior was made more comfortable and user friendly. And now you can see what the building turned into after the missile attack on the 6th of March 2022. As I said, this building has already withstood war back in time during World War II, and in 2022 it happened again. Let me remind you that we are talking about a historical building. At the end of 2022, the part of the building which was the least damaged during the missile strike was refurbished so that justice could be administered in the city of Kharkiv. Another story, very painful, absolutely terrible. So this, what you see here is Mykolaiv commercial court, which shared the building with the Mykolaiv regional administration. On the 29th of March 2022, the building got under attack, and you can see in the picture, and you could see in the previous on the previous slide, that the missile hit the building, and it was partly ruined. The most terrible part of the story is that the employees of the commercial court of Mykolaiv region perished as a consequence of that terrible attack. Their names were Anastasia Dolgova and Nadia Dorkhova. Another employee was heavily injured, but fortunately she was saved, and her life was saved. Another story. Apologies, I would want to continue with the Mykolaiv region commercial court, so you can still see the premises of this court in the picture. So despite terrible damage inflicted to the building, it has been repaired, not in full. Certain parts of the building were refurbished, and now they host not only the commercial court of Mykolaiv region, but also the territorial unit of the state judicial administration. The next slide, which is already there on the screen, demonstrates the Krasno-Limansk City Court of Donetsk region. It has been located in this building starting from 1992. The building has been recently renovated from interior and from exterior to make it more comfortable and user-friendly. But unfortunately, here you can see what the building looks like as of today. Now, another story of another court of another city, of Borodanka, which got under attack in March. I believe that you esteemed participants may remember pictures from Borodanka. So in particular, pictures of heavily damaged residential building with kitchen furniture and this decorations, the traditional Ukrainian decorations, which remained intact on the shelf. So that picture was made in Borodanka. And what you can see now in the picture is the Borodanka District Court of Kiev region. So you can see that the building was recently renovated, and but unfortunately it was destroyed in 3 days back in March 2022. The building was destroyed as a result of the air raids and heavy bombardments. At first, the windows were broken, but then the building was hit by air bomb. And in the right corner, you can see a picture of a courtroom, which can be recognized as a courtroom only by those metal constructions, which used to be part of courtroom equipment. When the city of Borodanka was liberated and when it was discovered that the court building is completely destroyed, it turned out to be quite challenging to find in Borodanka a building which would fit for the purposes of administration of justice. But we managed to do that. And here I cannot but mention the court team, court employees, court management. They are wonderful people. They are very dedicated people, and it became possible to restore the operation of Borodyanka court so quickly because of the dedication of the court team. They even gave their own money to speed up the restoration. Some of the court team members remained in Borodyanka while it was occupied, but immediately after they went back to work.
В березні 2019 року судді і працівники суду урочисто
And another story, it's about Vuhledar city court of the Donetsk region. 3 years before the full-scale aggression, the work on reconstruction was started. It was made possible thanks to UNDP project on improving access to justice, in particular with the involvement of EU projects, and also the Kingdom of the Netherlands. All in all, the reconstruction of the court cost over 2 million hryvnias. After reconstruction, it was almost exemplary courthouse.
Як говорять, клієнтоорієнтованості.
And it had all the best practices, client-oriented approach. And also there were measures to ensure effective organization of the work of the court, volunteer services, and many other model court practices in the building of that court. Unfortunately, the city of Vuhledar suffered first shellings and shrapnels, and the building of the court was almost fully destroyed. These events are what happened in the court. After the first attack, the personnel who were still there were coming back to the court, trying to save what was left undamaged. They were able to take servers with the very important information and part of the hardware. But then, after the building was hit, it was almost ruined. And even after some time, people who died were buried on the premises of that courthouse. And now it's impossible to get access there because there is active hostilities in place. And here we can just have a look at the next slides. They show the different courthouses that suffered because of the aggression and the scale of this destruction. No comments here. So here we can see that to be continued on the matters raised, as I mentioned, the buildings of those courts were damaged or that are impossible to be renovated and reconstructed. But without even those buildings, 97 buildings are damaged. For example, some courts lack windows, water, heating, ceiling, doors, internal walls, or other destructions that took place. Another example that I would like to share, it's Avdiivka City Court. In 2014, after the war broke out.
Бойових дій ще в 2014 році на території Авдіївки з метою збереження життя
Because of active hostilities, as back as in 2014, the work of the Avdiivka city court was temporarily suspended, and the city residents had to, in order to get their rights and interests protected, they had to go to other localities to get the protection of their rights. And in order to resume the operations of the Avdiivka city court of the Donetsk region, the state judicial administration,
в області, в Донецькій області, та керівництвом Авдіївського
both head office and the territorial unit, took a number of steps in order to ensure the renovations of the buildings. And there were 4 offices and some extra facilities for the court staff and for also the defense side. And then again, as with many other courts when the war broke out, just before the war happened, there was a decision that on the 11th February 2022, this court resumed its operations. It took a month after the decision was made to administration of justice to become operational again. Because of that, in a couple of weeks, the court again had to stop working. Because of constant bombardments and shellings, there was real threat to the court staff, and the building was severely damaged. Unfortunately, it's impossible to administer justice in that court right now as well. It should be mentioned that during the martial law, all measures are taken to, as soon as possible, resume the operations of the courts by joint efforts of the State Judicial Administration of Ukraine, courts, territorial units of the State Judicial Administration with local authorities. During 2022, there were special measures taken, like replacing windows, doors, internal doings up. And moreover, apart from the critical situation with the financing, as we know, it's in country in general, and especially such underfinancing is the case with the judiciary, we still were able to ensure some restoration activities in 116 courts. We need to say that the money required for full-fledged and all-round renovations will be clear after estimates are made. For now, the scale on financial losses cannot even be calculated because separate calculations are required for that. And given the fact that some places are occupied, it's virtually impossible to be done. And now we will see another couple of slides. So these are the slides on how renovations were done in courts. Some more examples. We see that the scale of the destruction is such great sometimes that it would be better to build the new premises based on the preliminary arrangements made. And we are very grateful to our international partners who, from the very first days of the Russian invasion, started providing international technical assistance. For now, this year of such solidarity and such resilience, all Ukrainians have become more resilient and brave, every day going to work, either in the armed forces of Ukraine or in places of hostilities. We prove our right to live freely on our land and to be the ones to determine our own destiny and fate. We are sure that we will win. We are sure that we will be able to provide rebirth for that, but we will never forget it. Thank you very much. Glories to Ukraine.
Thank you so much for these intense and vivid experiences and images you've shared, Mr. Serhiy Chernutsky, Deputy Head of the State Judicial Administration of Ukraine. This has been deeply moving and makes me admire even more the courage and integrity with which you are facing such a terrible aggression of destruction. Following topic is the best practices of court emergency planning to ensure safety of court employees and visitors, as well as security of courts, records, and equipment. We'll start with a presentation by Mr. Pablo Triasun, Deputy Head of the Court Security Service. Please, Mr. Triasun. Oh, I'm sorry, Mr. Verheeren, I don't know if there wasn't any change in the.
Oh, I'm ready to go, but
Okay, no, I had the script, I got with the presentation by Mr. Triasun, but if it's Mr. Verheeren, I'm going to introduce you too. I'm sorry for the confusion. Good.
So,
Oh, there he is.
hello, dear conference participants. It goes without saying that the topic that is raised today is more than vital for our country because of the full-scale invasion of the Russian Federation into the territory of Ukraine. The Court Security Service and the judiciary as such has now seen new challenges and new issues to be addressed because even though in spite of such full-scale invasion, the Court Security Service took all the possible steps to ensure that such safe operations continue as much as possible. Especially, we can see that some staff of the Court Security Service were transferred from the area that are full of active hostilities or where such active hostilities are very probable. And we can see that the protection and security of 87% of the infrastructure is protected. Unfortunately, because of the destructions of the premises and because of seizure of the buildings, because of the occupation, for now, of 88 courts and judiciary sectors institutions have been suspended, and these institutions are placed in 62 buildings. And because of the close proximity of the Ukrainian territory to Russian territory, the regions that had been partly occupied in Ukraine is mostly the one that suffered the most. As it was mentioned by Mr. Chernutsky, all in all, the 6 institutions that were subject to protection were fully destroyed, 10 partly destroyed and 50 damaged. And the court staff had to get adjusted to how they worked during the wartime and try to find a way how to ensure the safety and security of all the participants. And that's how all the tasks were done, and especially close to war zone, special precautionary measures were taken. To improve the efficiency of the operations if the situation got out of hand and got worse, there were the contingency plans on transferring persons to two secure places were introduced, and there were some guidelines and standard operating procedures in place. That is, the Court Security Service took all possible steps to ensure proper operations, and it's now 24/7 security, and we now have interaction coordination of together with the territorial defense units and other units that are acting. That is, both the law enforcement agencies and military administrations. And here I need to say that on the 7th of March 2022, the head of the territorial defense of the Armed Security Service issued order number 10 that made that the Court Security Service is to take care of special events, like, for example, to limit the movement of pedestrians and cars. Also, there were routes that were subject to supervision and control. Also, Court Security Service staff were engaged within 15 groups on liquidation of diversion and intelligence groups, and they made sure that the necessary elements are functioning in the society. Together with the territorial defense, there were judiciary institutions protection introduced, and in order to react properly if the situation goes worse, the territorial units of Court Security Service introduced the watch, and the special groups were introduced to prevent the attacks on courts, and they were given special weapons and medical kits and individual protective equipment in order to preserve the life and to save the lives and health. There were specific trainings in place, both for the Court Security Service staff and for the court staff during the air raid alarms or other threats. One of the key issues how to introduce the better security in courts were the vulnerability assessments, and there were places defined where persons cannot go in the case of emergencies and where they can go. So also such critical infrastructure facilities were examined, and when the full-scale invasion started, at some judiciary institutions that have bomb shelters, they were provided, such care was provided and protection not only to the workers of the justice sector institutions, but also to their family members. And in this case, such protection was ensured both for staff and for the family members of the staff. And in order to ensure that the justice is uninterrupted and integrity of case files, the territorial units of the Court Security Service took measures on transferring archives and property of 13 judicial institutions. If we are more specific here, it's 5 in Donetsk region, 4 in Luhansk, Kherson region 2, Kiev and Mykolaiv region 1 institution. And after the temporary occupation was over, the Vovchansk court was resumed, and also another section in the Kherson region.
Правосуддя, розташованих на деокупованій території, для визначення можливостей відновлення їх охорони.
The Court Security Service also conducts examination of court premises in the deoccupied territories in order to retake them under control. In the meantime, in other regions across Ukraine, the Court Security Service ensures safety and security according to regular procedure. And now I would want to express my appreciation to all partners for your assistance and support, and I'm ready to answer any and all of your questions.
Thank you very much, Mr. Triasun. Dear participants, given these presentation slides were written in Ukrainian, I want to stress what Ms. Juliana Pashina previously wrote in the chat box. You'll be able to download the materials of the conference, including the PowerPoint presentation in English of Mr. Triasun at the link she previously sent. I'm going to do it again using the chat box too. Thank you. Please now, Mr. Cornelis Verheren, Detective Superintendent of the Netherlands National Police, retired and international expert of the EU project Pravo-Justice. The floor is yours, sir.
Thank you very much. Ladies and gentlemen, the hard reality has made clear the nature and extent of the security threat from the war in Ukraine and how it affects the courts. We've seen an impressive video of the state judicial administration, so I do not see the need to mention all the various atrocities directed against the judicial authorities and the judicial organization in Ukraine. There will be some attention to the subject I'm mentioning now. I only say let's not underestimate the cyber attacks. But there's also the risk of high-profile trials of war criminals and its consequences after conviction. All threats can have serious consequences for the safety of judges and other parties in the court, and threaten the ability of the courts to remain open and functioning. It goes without saying that attacks on courts with heavy military weapons are, as it turns out, difficult to prevent, especially when they are also part of a broader enemy attack pattern. As you will know, it's then important that the court conforms to the evaluated information by the National Security Services and the appropriate early warning system in order to prevent or at least limit casualties. I would therefore like to focus today on various other security aspects of courts, like dealing with war crime cases. Let's first look at the topic from a general management perspective. Effective security management and a well-planned security organization work for any court and therefore also forms a good management base for a court in a hostile environment. Second slide, please. There are 10 essential factors for effective court safety and security planning. No doubt, you have already implemented a few, possibly provisionally, under the pressure of the current threat. Some of them already were mentioned by Colonel Triasun of the Court Security Service. First, operational security. If not already done so, the war might have forced you to develop or update the security guidelines. It is important to assess if these guidelines are being followed and for full safety, to establish that there is 100% compliance. The challenge here is to keep up with the safety rules, especially if they interfere with the daily routine. And after some time, hopefully, the sense of threat diminishes somewhat. Facility security planning. Under the current circumstances, I have no doubt that a self-audit survey of court facilities have taken place in your court. It gives you the need to know the strengths and weaknesses of the physical structure of the courthouse and its premises. Again, Colonel Triasun has mentioned here some activities. Emergency preparedness and response with a focus on continuity of operations. The current picture shows that most of the courts have found ways to continue to operate and serve the public despite the war. Emergency measures already taken need to be formalized and should contain a proper command structure, protocols, and a communication line. Disaster recovery. The attacks on courts in Ukraine undoubtedly have led to some procedures to recover lost or vulnerable electronic and other hard copy information. We come to the threat assessment. Have courts developed an effective national or regional, anyhow, tailor-made threat assessment protocol? Are courts, for security and safety purposes, able to identify serious threats in order to prepare themselves for the proper protective actions? I want to tell you more about that later. Incident reporting. This method is necessary in order to recognize a general or specific threat linked to the court in a war crime case in time. The method allows you to capture data on various security topics for both operational and management purposes. It was mentioned, of course, by the State Judicial Administration. Funding is another critical factor in the court security system, in any court security system, especially in the system in Ukraine at the moment. It directly concerns the State Judicial Administration and the budget allocated to them. It is conceivable that the State Judicial Administration is currently under great pressure to allocate the available resources in these extraordinary circumstances in such a way that the legal system continues to function. When determining the priorities for budget allocation, it should be clear that security of the court, its judges and other parties in the judicial process is of crucial importance. Brings me to security equipment and costs. There is an extensive range of technological security features. There may now also be a great and urgent need for technical security systems. Internationally, we see that in circumstances like these, the security industry offers a range of technical solutions. The application depends on the type and the level of threat, of course. Cost effectivity should be the line of thinking. Courts have been destructed, as we have seen in the presentation of the State Judicial Administration. Wherever and whenever possible, they will be rebuilt. We already saw an impressive number of repaired courts. This offers the opportunity to ensure that up-to-date physical safety measures are included in the design stage. Let us now turn to the threat against courts. The threat against courts in the Ukraine immediate war zone is obvious. But is there a difference in threat between the court in Lviv and the court in Poltava? This question cannot be answered simply because the nature of the threat as well as the level can differ. So, to effectively counter a threat, the one-size-fits-all solution is not sufficient. It is therefore important to take a more closer look to the process of threat assessment. What is the threat and the threat level? Is it moderate, substantial, severe or critical? When do you upscale or downscale your security measures? How long can you maintain the security measures at that level? Apart from the general security threats by acts of war, we live in a time where threats and acts of violence are directed toward courts and toward judges as a result of their official duties. For example, when judging war crimes. It's crucial that every threat, especially when directed against a judge, be taken seriously and addressed. But the reality also makes it clear that the security risk can arise in a court because other parties in the judicial process are threatened. Courts should have in place a rigorous, tailor-made process to be followed when threats are received. Next slide, please. There are 4 essential steps in the process of threat assessment. And you can read them in the slide. Identifying the threat. Determining that the information you receive is indeed a threat and not simply a statement to intimidate or to ventilate anger or frustration is a critical first step in the process. It must also be established whether the threat is general or related to an ongoing war crime case or even to the defendants. The next step is assessing the threat. The next step is to assess how significant or serious the threat is. An assessment should be conducted to determine the likelihood that the person or persons making the threat will actually carry it out. That assessment must be made of 4 characteristics relating to the initiator of the threat: intent, motive, opportunity, and ability. Intent is a purposeful course of action. Motive is the emotion, the desire, the psychological need acting as an incitement to action. Opportunity is required for the threat to be executed. Ability is having the resources and possibility to take the action, to do the attack. Of most concern, of course, are threats by those suspects who possess strong intent, powerful motive, ample existing or created opportunities, and considerable ability. When the threat was received by security services, it has most likely already been analyzed and evaluated. Once the suspect has been identified and an assessment has been made, a determination needs to be made to the threat that the threat is serious enough to warrant further action. The proper security and law enforcement organizations will investigate the threat and the suspects. They also will investigate if the threat is against one specific court, more courts, or all courts. If possible, they will take measures to try and eliminate the threat, but until then, the court needs to manage the threat. Once the assessment and the investigation are complete and a determination is made that the threat is real, the court must take preventive or management measures. The type and extent of the security measures depend on the type of threat and the available resources. I give you a simple example. A standard measure is that there will be created an inner ring and an outer ring, which may or may not be spacious. They are organized around the court. For special control measures by the police in the outer ring, a regulation may need to be enforced for the duration of the operation. It speaks for itself that the Court Security Service is closely involved in this. In every court setting, there should be a specifically assigned person, for example, the Chief of Staff, for handling threats, and he or she should be properly trained. It is also important to train judicial officers and court staff on how to report threats. I heard from the Court Security Service that some initiatives in this are already made, because it will help to give court managers accurate information as quickly as possible. This brings me to incident tracking. I already mentioned the importance of an incident reporting system. Incident reports need to be regularly and systematically analyzed to see if they contain any indication of current possible threats against judges or court staff. When a threat is received, the system should be checked for possible previous reports related to that threat. A basic activity. If I'm well informed, the Court Security Service has a system for incident reporting. This system should be accessible for other court staff. Having two different systems for the same goal works counterproductive. It is important to establish and maintain contact with security and law enforcement agencies at the local and regional, maybe even the national level. Do not let your information position depend on personal contacts. Provide formal and clear lines of communication. Get a seat at the table. Connecting the dots that may link individuals or incidents together can serve to identify threats in a more timely fashion and thereby minimize the risk. How vulnerable are courts? The day-to-day business of courts can be brought to a sudden stop in an instant and have it stop for weeks by a cyber attacker in a dark closet halfway around the world. In order for law enforcement to proceed unimpeded, it is necessary that the safety of the investigation team, the prosecution and the judges is guaranteed. This certainly also applies to the investigation and trial of war crimes. But we must also take into account the factor of public access to the courts. Public access to the courts guarantees the integrity of judicial processes by demonstrating that justice is administered in a non-arbitrary manner, according to the rule of law. Openness is necessary to maintain the independence and impartiality of courts. Therefore, the court's leadership should strive to develop its security plans in such a way as to ensure its operational continuity and the rule of law. In recent years, in the Netherlands, a new generation of ruthless international criminals has emerged, and the number of transports of defendants by a special team has increased significantly. Authorities are now discussing the idea to have a courtroom in the prison. It prevents problems during transport, being the most vulnerable factor for liberation or escape attempts. So, the elimination of risky transport should improve security. However, the idea is objected by the judiciary as it affects the openness of the trial. We see that in a number of European countries, a few courts have been designated to deal with high-profile and high-risk cases. The advantage is that only those courts need extensive and advanced security measures and systems. This approach saves a lot of money and manpower. The court's performance needs to be balanced between security and public court hearings. You have to find an adequate approach to secure the court and the trials in the courtroom when you, as a judge, also has to say about openness of the trial. Next slide, please. Security is a team effort and a shared responsibility. No single individual, team, or organization, be it the state judicial administration, the courts management, the court security service, the court staff, from management to operations to support, carries the burden of security in totality. I want to focus now on the threats against judges. Is this slide 6? Next one. Thank you. Protecting judges has never been more difficult and expensive as before. Judges are subject to threats far beyond the courtroom due to the wide availability of personal information online. In Northern Ireland, judges were threatened because they represented the British government and because they judged terrorist cases. In order to limit that threat somewhat, the anti-terrorism law stipulated that criminal cases against terrorist suspects would be handled by a singular judge. It meant that extra security measures only had to be applied to those judges handling terrorist cases. The threat could be such that the judge temporarily stayed in a neighboring country and had to be transported by helicopter from his home address to the premises of the court for court hearings. These far-reaching and extensive security measures could be sustained because only a few judges were involved. Judges of international tribunals trying war crimes receive standard security. The nature and level of these security measures depended on the overall threat. Not every criminal case of a war crime will lead to revenge actions. This may depend on the importance the opponent attaches to the case or to the position of the accused, but nothing, of course, can be excluded by definition. It's crucial that every threat directed against a judge be taken seriously and addressed. Courts should have in place a rigorous, tailor-made process to be followed when threats are received. Let me inform you about an interesting development in the Netherlands to offer special protection to prosecutors and judges in cases of very serious crime. In these cases, an analysis is made of the level of threat, both concrete threats and imaginable threats. The court also looks at the content of the case and at the criminal network it's dealing with. Has it happened more often that individuals of this network have made threats not just to the judiciary, but also against other people? When it is concluded that persons in the prosecution and education of these cases are at risk, they can perform their duties anonymously. Anonymity can also count for investigators and expert witnesses, but that's more often and in more cases. According to reports from the Public Prosecution Service in the Netherlands, public prosecutors have been presented anonymously in 39 cases in the past 2 years. In most files, the names of the prosecutors have been replaced by numbers. In 9 cases, they were not allowed to be filmed, drawn, or painted. The Bar Association protests against these measures. It states that this hinders the openness of the trial process. The Council for the Judiciary states that also anonymous judges at any moment could be a real solution to counter the threats. For lawyers, prosecutors, and judges who handle serious criminal cases, anonymity offers a solution that can be forced to adopt to guarantee their safety. What level of protection for Ukrainian judges is adequate? Should all judges who try war crimes have close protection? Is a lower level of protection sufficient? How far does the protection of the judge extend? Should his family members also be protected? What does all this mean for the capacity and the capabilities of the protection units? This can be answered undoubtedly by the Court Security Service. Many questions to which unfortunately no unequivocal answer is possible. Because, as I said before, the type and level of measures depends on the level and evaluation of the threat. A tailor-made approach is needed to come to an efficient and effective security system. Fact is that threats made against judicial officers can seriously interfere with the functioning of the courts. While such threat cannot be eliminated, they can be effectively identified, assessed, investigated, and managed. A thorough, all-encompassing security process can minimize the negative impact that threats have on the judicial system. And, even more so, a solid process can also potentially save the life of the judge. Given the working conditions, the type, the intensity, and the time of the investigations, not only investigators but also prosecutors, judges, and court staff are exposed to psychological pressure for an extended period of time. It goes without saying that a professional approach is required to prevent unwanted mental stress. This requires the provision of psychological support with active participation of the court's leadership. Despite the extraordinary circumstances and the great pressure on the workload, The appointed manager should create the necessary work conditions and the proper moral and psychological climate in the team. Next slide, please. To conclude, some words about the protection of witnesses in war crime cases. The duty of care for witnesses' protection rests on the state. That obligation starts when the witness presents a statement to the police or when the police approaches the witness for a statement. It requires the state to try and provide the necessary protection when a witness is in danger as a result of cooperating with the police and the judicial authorities. From war crime cases up to now, we learn that evidence of war crime strongly relies on witness statements. These witnesses must be found and be willing to make incriminating statements. In specific cases, such statements cannot be given freely. Witnesses may be intimidated or threatened with reprisal. Special care should be taken to obtain useful evidence when these witnesses are traumatized. We discuss this topic also in our coming war crime training sessions. Next slide, please. A witness protection program is a covert program based on witness protection law or formal regulation. It contains strict admission criteria that provides for the relocation and change of identity of witnesses whose lives are threatened by the defendant or a group related to the defendant. You know that additional procedural protection measures may be requested from the court for the duration of the testimony, such as the use of pseudonyms in witness statements or suppression of the identity of the witness if permissible under the law and if that does not undermine the weight of the witness testimony and makes it counterproductive. A large number of countries around the world have established specialized witness protection programs or have created legislation for this. Experience has shown that assistance and protection measures bring positive results. They increase the confidence of witnesses and motivate them to come forward and testify. Ladies and gentlemen, finally this. Should we consider, because of the security risk and likelihood of absentee verdicts, to leave the education of war crimes to one international tribunal and only judge the leaders of the war? I will not answer that. For that, I want to give you the statement of the spokesperson for the relatives of the victims of the attack on flight MH17 after the verdict of the District Court of The Hague last November. As you know, the attack, which took place in Ukraine on the 17th of July in 2030, resulted in the death of 298 people, and the court came to its conclusion after 2.5 years of investigation. The excitement among the relatives of the victims of flight MH17 was great. They embraced each other after the court in The Hague sentenced 3 of the 4 suspects to life imprisonment. 1 defendant was acquitted. The spokesperson for the victims' relatives said, "People have been looking forward to this day for 8 years. For the relatives of the victims, it's a hugely important milestone in the search for truth and justice. We think the trial is more important than the verdict. We wanted an impartial judge to determine what happened. The fact that it has now happened brings relief. That the convicts will probably never end up in jail, we knew in advance. But it helps us that the independent judge has confirmed that all the evidence about Russia's role in the disaster is reliable. This ensures recognition and peace of mind for many relatives. It gives us relatives space or enables us to take more to take more distance from the MH17 disaster, which we can never completely put behind us. Thank you.
Thank you very much, Mr. Beheram, for explaining so clearly such a complex and sensitive subject, and for elaborating on the process of threat management, the preservation of life of the judges, and the witnesses' protection, as well as the stages that they all entail and the entire development. The following topic is the security of court premises and continuity of court operations. Please, Mr. Timothy Devil, Vice President of the Justice Management Institute, expert for the USAID Justice for All activity, and longtime IACA member. The floor is yours.
Thank you, Luis and Cornelis Verheyen. Good afternoon. My name is Tim Dibble. I am in Philadelphia in the US. We follow what is happening in Ukraine very closely and think about our Ukrainian friends often. I'm the Vice President of the Justice Management Institute. As Luis just said, we have been working with Justice for All and previous USAID projects to provide technical assistance for a number of initiatives, as well as to help with the training of judicial administrators for more than 8 years. At the Justice Management Institute, we provide judicial administration training and technical assistance to courts and the justice system. Unexpectedly, my previous career and postgraduate education were in architecture and urban planning at Columbia University in New York City. So talking about courthouses and court facilities is something that is very welcome for me. Next slide, please. The three areas we would like to briefly address are the background for the presentation, related specifically to the work that we have been doing with the Justice for All and USAID. A recent report that was produced on judicial administration of war crimes cases, about which many of you are likely familiar, and a facilities perspective related to the High Anti-Corruption Court, which Bogdan will talk a lot more about after my presentation. The second topic is Ukraine building norms related to courthouses. The building norms provide the baseline for what is needed for a courthouse and the security of judges, staff, and the public. They're really quite good and compare very favorably to many of the building norms and standards we see in the United States and in Europe. Finally, the third topic is guidelines for reconstruction of existing courthouses that have been damaged or adaptive reuse of other buildings for courthouses, which the Colonel was talking about earlier. Next slide, please. Late last year, Justice for All and the Ukraine Judiciary commissioned a report on judicial administration, which was presented at the IACA conference online. One area we studied was related to infrastructure and security, especially for war crimes cases. The other two authors were Evelyn Anoya and Ben Wilson. Many of the issues presented today were adapted from that report. The High Anti-Corruption Court was a new court founded under recent legislation. It was a powerful step forward in addressing concerns about government corruption. Ultimately, an adaptive reuse of a bank in downtown Kyiv was determined to be the best option for the court. Again, Bogdan will talk more about the hack in a few minutes, as is colloquially known. Next slide, please. Related to courts which will try war crimes cases, the November report made a number of important recommendations for infrastructure. Many of the current district or oblast courts are not really designed to accommodate high-profile cases and the media attention. They're not also really large enough to accommodate some of these pressures. We recommended designating specific courtrooms and courthouses for these purposes. This happened in the initial Shishkimarin case, where they had to transfer the trial from the district court to a nearby appellate court. Due to extreme security needs, we recommended both special ways of moving prisoners through courthouses, as well as supplemental procedures to ensure everyone's safety. Supplemental security technologies include additional screening, duress alarms, and other features to help judges and staff. The most important recommendation is to use video hearings and testimony as much as possible. This was also referenced earlier. There are challenges with this approach inherent in the capacity of the district courts to manage these technologies or even to have the infrastructure for them. But they enable the court to reduce the number of persons at the courthouse and in courtroom. We will talk about this more in a few minutes. Cornelis referenced this in talking about being able to conduct some hearings from the jail or the prison. Next slide, please. Many security measures were planned for the High Anti-Corruption Court. They included a single point of entry, public screening as is necessary for all courthouses, segregated circulation and parking, and courtroom security. Most important, the judges received additional security personnel going to and from the courthouse and their homes. Next slide, please. This is an image of the High Anti-Corruption Courthouse in downtown Kyiv. It was a large bank. Remarkably, the conversion was quite straightforward, although few spaces were large enough for the larger courtrooms that were needed for the courthouse. We were very much involved in planning for the new court. Next slide, please. It is important to recognize that Ukraine building norms for courthouses are relevant and applicable and mandatory, so planning for security and continuity of operations in courthouses plan to be rebuilt or renovated in war zones. It is very likely that the work that's already been done is in full compliance with the Ukraine building norms and that these are used as the guidelines for renovation and reconstruction. We divide courthouse security into 3 zones: highest security areas, segregated and secure areas, and public access zones. Next slide, please. In the highest security areas, they are primarily the areas for securing prisoners in the courthouse. They should never be breached or crossed by the public or staff, but sometimes that kind of interaction of circulation is necessary in older buildings. We've done work in courthouses where, even though they were built in the 1970s, the prisoners are having to be transported through back hallways that are being used by judges and staff. And these procedures have to be coordinated very closely. Control rooms are typically high-tech areas with banks of surveillance monitors. In a modern courthouse, they would also have control over all the doors through which prisoners are taken, and often through all of the major doors, even that are used by the public, with remote controls by the courthouse security. Finally, storage of classified confidential documents is very important for war crimes cases, but also increasingly important in high-profile cases in courthouses and war zones generally. The sections that reference these types of security measures are listed at the bottom of the slide, just above the term red zones, which is what we use to diagram these when we do designs and planning in courthouses. Next slide, please. Segregated and secure areas include judges and staff and other areas where the public might go but need to be secure and or confidential. Primarily, these would be witness and jury deliberation rooms for the public. Also, other service rooms should be secure and inaccessible to the public, and often behind some type of zone that is accessible only through security access cards or other measures. Next slide, please. Green zones, what we call green zones, and often diagram this way when we do courthouse planning, are public access areas in the courthouse that are likely the easiest to set up. They should be designed into buildings that are reused from other functions, even if those functions, the courthouse is not what it was originally designed for. Most important is a single point of entry for the public and screening by court security. So the bank that was converted to the High Anti-Corruption Court also has a secure access point for judges and staff. The registry office often has public counters, but the staff are in secure areas. Courtrooms and conference rooms are public assembly spaces. Most important to public assembly spaces is life safety, getting everyone out safely in the event of a fire or other emergencies, such as a bomb warning. Next slide, please. The most important features of reconstruction or adaptive reuse are internet access, central location, access to public transportation, and redundant or local power. In a lot of places around the world, this is provided by generators or other kinds of battery backups. Often these don't have enough capacity to last for very long, but they do allow the court to make a transition in the event of emergency. By definition, a central location would be in a commercial district for reconstruction or adaptive reuse. Residential districts are not permitted by Ukraine building norms, so this naturally lends itself to providing a central location and looking for a commercial space which would already be adapted for public use. Next slide, please. This was talked about a lot earlier. This is a picture of the Kharkiv Court of Appeal before and after bombing. A realistic assessment of an existing facility, and this has already been done for 13 of these facilities that have been bombed or damaged in the war. This realistic assessment would need to determine if the work to repair it is worth it, at least temporarily. Water and fire damage are sometimes the hardest things to remediate, to fix, because of the potential damage to the structure. Direct structural damage is, of course, the hardest to fix. Next slide. It's hard to overestimate the importance of technology and planning for renovated courthouses in areas recovered by Ukraine or damaged elsewhere in the country. That's because technology has provided sustaining justice and governance, both in Ukraine and even in the rest of the world. As an example, during the pandemic, we've seen this in working with courts and justice systems around the world, is that technology is being leveraged. Many courts are leveraging technology to provide greater accessibility to the public and lawyers even after the pandemic. These kinds of tools are critical in war areas and especially in Ukraine currently. These possibilities were presented at the last IACA conference in Helsinki. Examples of the types of technologies that reduce the impact on the physical courthouse include what's listed here, these video hearings and video witness testimony, which are critical. These are most applicable to evidentiary, investigative, and pretrial hearings, for scheduling conferences, and some simple trial matters. Most trials would still be scheduled in person. Case management system, a digital legal record, is crucial. In order to make use of Ukraine's case management system, fairly consistent access to the web is needed. This is also very important. We've discovered this in other disasters around the world where hard copy or case files are destroyed, and a digital backup, a digital legal record, is absolutely critical for the ongoing operations of the courts and the justice system. Digital evidence, noticing and summons, and finally communications to the public. In looking at the issues around digital evidence, some of the challenges that need to be addressed in Ukraine justice systems is the link between the prosecution's electronic digital evidence tools and the court's use of digital evidence in their case management system, and some legislative changes that are needed for e-noticing and e-summons. Next step, please. Next slide. The development steps are pretty logical. How much space is needed? A space program is critical here. It matches functions to quantities and sizes of space. Next, to determine what is available in both the existing courthouse that is able to be reconstructed, or what's available in other commercial facilities. Is it worth it to renovate a damaged courthouse, or easier and more logical to reuse a commercial building? What will it cost? Is cost a determining factor? Where will the money come from? Many of these issues are managed quite directly by the Ukraine government and by Ukraine courts. It's something that they do very naturally. It's true for any complex organization. I think the biggest issue here in terms of being able to get the resources and being able to apply the resources in a way that's effective. Who and how will construction be undertaken? Steps and procedures are usually quite detailed and prescribed. Then finally, furnishings and occupancy, the final stage. what is absolutely remarkable and amazing to see, even in the presentations today, is the amount of effort that is being put in Ukraine to ensuring that these courts have continuity of operations and that the damaged buildings are renovated and reoccupied as quickly as possible by the judiciary and by the lawyers and the public to continue the consistency and continuity of the government and courts in general. If there's any questions, we'll stay around for the end of the presentation and turn it over at this point to Bogdan.
Thank you very much, Mr. Timothy Devil, for providing us with such a great and practical description. Differentiation of areas by colors look to me as an eminently clear way to set priorities. By the way, Mr. Marcus Zimmer, ex officio and lifetime IACA member, suggested the inclusion of versions to have handled materials and the development of continuity operation plans, given the situation that Ukraine is facing. So his insights are always very valuable to me too, as well as your presentation, which has taught me a lot. Thank you so much, Tim. Now we're going to the participation of Mr. Bogdan Kriklivenko, Chief of Staff of the High Anti-Corruption Court of Ukraine, board member at the non-governmental organization All Ukrainian Association of Court Employees. Please, Mr. Kriklivenko, the floor is yours.
Thanks a lot, Dr. Palma. Доброго дня всім, колеги. Дякую колегам, хто допоміг вивести мою презентацію на екран.
Dr. Palma, thank you very much, dear colleagues. My greetings to all of you. Thank you for being here. I'm also grateful to the technical staff for demonstrating my presentation. I would also want to express my gratitude to Tim for mentioning the High Anti-Corruption Court in his presentation. Indeed, we did work together. There was an occasion in the past. I would want to highlight in my presentation certain peculiarities of High Anti-Corruption Court operation in Ukraine through the lens, but not only of the existing circumstances in Ukraine. You might not hear now, but the air alert is on in Kiev right now. I can hear it from my office. So right now, while we are having our conference, there is a threat of air attack in Kiev. By the way, this is the third air alert for today, but despite all, we continue operating. So I will go down to the content of my presentation. There is a package of security guarantees which is provided to judges of the High Anti-Corruption Court together with members of their family. So what are the components of this package? They are the following: safety of judges and staff, safety of participants to proceedings and visitors, and security of court infrastructure and information. I guess that my predecessors, previous speakers, highlighted these points, these bullet points in their respective presentations from different angles. It has been mentioned today that no less important is the cybersecurity, and due to support of our partners and because of the challenges we face because of the pandemic, we have already made we have already covered a part of path towards greater cybersecurity. Next slide, please.
Наступний слайд, будь ласка. Дякую. Якому зазначено про те, що суддям надаються додаткові
Now coming back to physical security of judges of the High Anti-Corruption Court. So Article 10 of the law on High Anti-Corruption Court, judges are guaranteed with personal and personal security and safety together with their members 24/7. And it is the Court Security Service that is engaged to and which is actually responsible for ensuring such security. Law on HACC is the only one containing such security-related provisions. We have already mentioned and remembered today the terrible days of February and March 2022, when the risk of siege of the city of Kiev and was very high, and the probability of occupation of Kiev was very high. And let me remind you here that the Anti-Corruption Court is located in Kiev. So we faced that threat of occupation and interruption of our activity. In the meantime, the court could not suspend its operation because it is not envisaged by the existing legislation. So we could not allow evacuation because it would mean violation of terms of proceedings and so on. That is why the High Anti-Corruption Court never stopped its operation. It was administrating justice during the whole period of active battles in the suburbs of Kiev, and everybody, including judges and court employees, remained in Kiev and continued performing their professional duties from the very first days of large-scale war until the 28th of March, when the enemy troops left Kiev region. The high, please demonstrate the next slide. The High Anti-Corruption Court is deeply involved in the matter of ensuring security and safety. We have very close relations of cooperation with the court security service of Ukraine. We have held a series of trainings over the last 2 years. I'm talking about joint trainings. That is why when the large-scale war started, the majority of the judicial corps and the court employees were well prepared. They knew what to do in the emergency situation, what to do in case of takeover of the building. They knew how to evacuate documents, how to make backup copies, and so on and so forth. And actually, that's what they did. Some of these actions were actually done when the war started. And in the meantime, let me remind you that the law on martial law provides for continuous operation of the judicial system. That is why there was no possibility for the High Anti-Corruption Court, because this is the only court of a kind in the country, to suspend its operation and to take time to evacuate to a safer place. So again, the High Anti-Corruption Court works very closely with the Court Security Service. However, we understand that this is a separate authority. That is why we make sure that this is there is sufficient regulatory framework for our joint cooperation and joint efforts. In this slide, you can see training provided by British. That was a training on emergency aid and technical medicine, in particular in case of air raids and air bombing, air attacks. So you can see people wearing uniform in the picture. They were our trainers, and in the picture you can see the trainees demonstrating what they learned during the training. Fortunately, we didn't have a chance to apply this knowledge in practice yet. Now, a few words about cyber security. All of the employees are aware of the necessity to back up all important information. As it has been mentioned by team, it is necessary to have backup channels to guarantee stable access to internet. So we do have 2 lines of connection, of internet connection, and in addition, we have Starlink because under the existing circumstances, this is the only way to have uninterrupted connection.
Another important thing is new challenges that come up in our work. The war is ongoing, and in our premises and corridors, we can see representatives of law enforcement agencies and military personnel that come to the courthouse with the weapons. They have the right to carry weapons. We can't prohibit entrance for them, but the court is under an obligation to create conditions to identify the presence of such arms and also the fact that it's properly handled. Also, we have metal detectors and scanners for all persons who come to court, and we have two types of keys: master keys for court security service, and then the same key that closes in the personal firearms of a citizen who comes, but we don't make any exclusions for any of the visitors. Everyone undergoes security check, unless, of course, the convoy sections will also have persons who are transferred and who are such escorted, and then such convoy staff has firearms and they do not hand it over during their work in court, but it becomes an everyday task when the visitors come to court, and we need to ensure a place where they can store their weapons. And I want to finalize that working during the war, we need to understand that all these new challenges and threats that are around, we need to clearly, our staff has to clearly go through specific trainings and communications on behavior, on dealing with emergencies and awareness of emergency situations, and day-to-day work is in fact filled with extra challenges. As I mentioned at the beginning of my address, it's been 3 times for today that we had air raid alarms, and the court staff members are obliged to answer clearly where the closest shelter is, how persons can get there in the quickest way possible, how they can get information on the adjournments of court sessions, or be informed of some emergency situations that can happen. We believe that the territory of the court is the territory of security, and our task is to create safe conditions where we can continue to administer justice under any circumstances. Thank you all for your attention. I hope us all to get victory as soon as possible, and so that these trainings and preparation and conferences on security are only a good example that none of you, dear foreign participants of our conference, have to use. Thank you.
Thank you very much, Mr. Kiklibenko. War implies extraordinary and frequently unpredictable emergencies and threats to security and safety in the courts, including visits of people with the right to bear arms precisely because of the former. To me, it is just admirable the brave and organized way in which you are dealing with them. We'll now start with the last topic of the conference, ensuring information and cybersecurity in assistance and the services of the judiciary. Please, again, Mr. Serhiy Chornutsky, Deputy Head of the State Judicial Administration of Ukraine.
Так, вітаю, колеги, ще раз.
Thank you, dear colleagues, again. On information security and cyber security, and the importance of these matters has already been raised by Mr. Bogdan Kryklevenko. Indeed, that's a very relevant and topical issue, and it's becoming even more relevant with the beginning of the war, when such attacks on the part of the enemy have grown exponentially. It's a very relevant issue on the one hand, and on the other hand, the issue of information security is quite difficult to be discussed publicly, because all the issues related to present or absence or the lay of the land are not of the nature that can be publicly discussed. However, all in all, I will try to cover the setting that we have right now and the circumstances that we right now have in the judiciary. Indeed, for many years in the judiciary, there were elements of cybersecurity and information security created. All of that was being created in the conditions of underfinancing and tight and budget constraints. And these challenges have become even more complex in the recent years when all the money is now transferred and allocated to fighting the aggressor. All in all, if we look at that, we see that in the judiciary there are some elements, some fragmented elements for ensuring security and information security and cyber security. However, unfortunately, there is no complex solution. They provide for minimum level protection and the minimum measures that can prevent such things. It's hard to arrange it because they're local ones and local solutions that are deployed in courts are different from one another. Even solutions that are in our data processing center is also different, and they are arranged for some types of e-services or e-functions, and there isn't a single managing point to manage everything in a centralized manner. It's as far as current system is concerned. It means that there are no complex solutions. There are fragmented local solutions that are unfortunately not interrelated, and that's why they are difficult to manage. But somehow they provide a minimum level of security. Next matter to be addressed is the fact that we have now faced new challenges, first with the outbreak of hostilities of Russia against Ukraine, and when the cyber attacks have increased. At the same time, we now see a greater need for remote work of both the court staff members and the judges, and the judiciary, to be frank, wasn't ready for that because all the services that were developed for working in courts were local. They were provided for working on site on the court premises. It's as far as the court staff members and judges are concerned, and the public services for citizens didn't in any way influence the work of the courts. That's why, in order to arrange the court operations as per the requirements set by our empowered cybersecurity body, unfortunately, we didn't have this software. That's why we had some challenges. However, there was a need to ensure the new operating modalities, because especially in the first month of the war, a lot of people were forced to fled and they worked remotely. That's why in a very smooth and urgent manner, we tried to make sure that it's possible to work remotely with meeting most basic level of such operating modalities. Maybe it wasn't yet possible fully up to the letter of the law at the legislative level, but however, upon the responsibility of respective managers, we used some software that would make such work possible. Of course, such access and protection of this access was it had some level of protection, of course, but we were based on what we had. About some drawbacks of the judiciary, we can see some consequences of the cyber attacks. Before the war, we were able to manage such cyber attacks, and the consequences were not that huge. But with the beginning of the war, just in January, I guess it was January 2022, that there was a massive cyber attack, and we had to recover services within a week or two. It took a lot of time, and even there was some information lost, although it wasn't important information. Thankfully, all the judiciary, all the case files and procedural documents were recovered. That is the situation as far as the cybersecurity is concerned. However, we also have a complex vision of how it should be. And as far as UJITS is concerned, there is a whole set of information security and cyber protection. And all these measures have complex solutions, and they are provided for in the concept of informatization concept and building the full unified judicial and telecommunication system for 2022-2024, given, of course, subject to financing because there were some budgetary constraints, and the complex solutions that I will cover shortly. So within this program, we see that the building of centralized infrastructure and cyber protection is provided for, that is creating a security operational center, also ensuring the functioning of the infrastructure in physical divided systems, also creating the second backup data center, also building complex information security protection, the system that is partially built, and also a number of activities that are to be improved or introduced, like centralized managing of the accounts of the users, also settings and hardware settings, and a must-have of backing up all the relevant information. Also, it's another point important for us is to see the automatic backup and recovery of data, accounting the maximum load at a given time, and introducing complex approaches to information management. And all these are the complex solutions provided for. It's approved within this concept. And there is this specific expertise by the dedicated body within Ukraine, that is the Ministry of Digital Transformation. And in order to implement this complex solution that would meet all the requirements, it's necessary to have resources. And for 2021, it was about 380 million hryvnias, and for now, we are not able to implement this solution because of the lack of resources. In order to estimate whether we have chosen the proper solution and whether this was properly addressed, I mean, we have engaged within the activities of the Ministry of Digital Transformation. We also initiated with our partners the audit of cybersecurity together with our USAID partners in order to make sure that we have chosen the proper way to move forward and to find resources or to properly finance this project. This confirmation of such an audit was received, and we expect after such an audit to get respective results. And that is the first solution that we need to make sure that we are on the right track and that there are some viable results. So to cover it simultaneously and to see the complex solution that will be introducing as many measures as possible and as few risks as possible, there are some operational tasks that need to be supported at least at that the level of that fragmented solutions, that measures, security measures that are now supported and that we have now. First point is that we have a number of licenses on security. I will not be covering the names of the names of the software. They are to be finalized. We don't have too many of them to finalize. It of course takes money and it takes time to finalize. For us, it's a very practical issue, and we have server equipment and the service support of which, again, I will not tell when, but it is about to run out. So it's very important to have it in order for the service support, because if it's suspended, there may be different events, not very favorable ones. We understand what might happen if this service time expires. Another point is also prolonging licenses for a number of other products or having in place the software used both in ports and locally by persons at their private laptops. In particular, legalization of the software for courts and justice sector institutions, mean operating systems and other equipment like Office and other user software that in particular is to be updated to ensure that there is it's secure in case there are some threats. Such a need is about 96 million hryvnias. Also, such data centers legalization and also optimizing the consumer systems and the security systems that are processed and secured, and that for that to legalize that we need about 120 million hryvnias. These are the challenges that I covered that what requires operational support and urgent support even without constructing a complex solution. But in order to have specific, whether good or bad, but still solutions that are workable and that prevent interruptions and interferences and that ensure that there is information security in place. What we have done so far, given the resources that we have.
Тобто з цього року ми для підвищення безпеки передачі даних між нашими
Starting
центрами.
from this year, in order to ensure greater security while exchanging data between courts, we introduce renovated encryption solutions. This novelty is expected to achieve greater security, which is in line with the existing legal and regulatory framework. That will also allow to prolong the security certificate, which is issued by the Commission for Security of Information, National Commission for Security of Information. We will also streamline we will also streamline the exchange of data in terms of data security, because previously external providers helped us to ensure security of data. They were doing it in a particular way, which is not fully in line with the existing regulatory requirements. So as I said, what we want to have for the future is proper encryption solutions so that data could be safely exchanged. What we also envisage for 2023 is establishing cooperation with the National Center for Cyber Security. We have signed respective joint documents, sort of memorandum of understanding with the mentioned center, with the specialized department for cybersecurity of the State Security Service of Ukraine, and with some other line institutions. This is a short outline of what we can discuss with you, colleagues. Should you have any questions, please do not hesitate to ask them. And last but not the least, there's another challenge the judiciary faces. You may have heard that at the end of last year, the decision was made in respect of courts, all courts and all judicial institutions such as SGA, territorial departments such as High Council of Justice, etc., to be included on the list of critical infrastructure. So this is something which was put on the table for discussion last year. There is no final decision yet, but if there is a final decision and if such a decision is in favor of what was suggested, then there will be greater requirements toward courts and judicial institutions. in terms of security. Thank you.
Thank you very much, Mr. Charnutsky. It's been enlightening the manner in which, including license-related matters, you proceed to protect and preserve the data and records, keeping cybersecurity up to date. And as a result, judicial independence, the essence of justice itself, is properly preserved. Please, Mr. Serhiy Sushenko, Legal Advisor, USAID Justice for All Activity.
Дякую, пане Пальма. Колеги, попрошу вивести на екран мою презентацію, будь ласка. Дякую. Отже, наступний слайд.
Thank you, Dr. Palma. Please show my presentation. So as it has been mentioned by Mr. Charnutsky, the war brought about new challenges before the judiciary. There is a need to facilitate remote administration of justice, which would be safe and secure. Here, I cannot but mention that global expenditures for detrimental program solutions and software constituted $1 trillion, which is more than the capitalization of Microsoft. As we could see from the previous years, even before the war, courts are vulnerable to hacker attacks worldwide. So not particularly in Ukraine. There were hacker attacks in the US as well, for example. So when it comes to remote work, remote operation, it is not something completely new, considering the pandemic's experience. However, there are some issues, problematic issues which arise in this connection. Not always court employees, for example, can bring back and forth or carry back and forth their equipment, and in this connection, they may use their home PCs, domestic network, etc. So the problem here is unprotected exchange of emails, malware, phishing, use of unprotected or even protected but public Wi-Fi networks, etc. This leads us to a conclusion that there is much higher risk to get malware or some virus when using domestic network compared to network at the workplace. Now, speaking about video conferencing, Ukrainian judiciary has special applications to use video conferencing. However, publicly available instruments such as Zoom, WebEx, Teams are also, and other platforms are also widely used, including for working purposes. And this is something which brings about additional risks because the simplest situation, the link can be sent to the wrong person. Not to mention that Zooms or WebEx or other sessions can be easily interrupted and the perpetrators may have access to personal data of the participant or to some sensitive information which is disclosed during the meeting. Now, phishing emails. How to identify a phishing email? It usually looks just like a regular email from your bank, for example. So the best decision would be not to open such messages. However, if you have already opened it before following any links, one should read attentively what is written in the plot of such an email. For example, Russian hackers send often such phishing emails, but fortunately they are not very good in Ukrainian language, so you can identify many orthographic mistakes there. And besides these emails often contain some factual mistakes, such as references to federal legislation, which does not exist in Ukraine, or links to or hidden links. Now let us proceed with password security. It is absolutely necessary to make sure that your passwords are secured, and in order to achieve this high level of security, one needs to change passwords often. It is not advisable to generate a password which would contain some obvious information such as your name or name of your spouse or your children, etc. It is necessary to make sure that the password is long enough, that it contains capital letters and some symbols and figures. And it is desirable to make the password look as random as possible. Another very common mistake, and again, the simple one, but very common. We use many services these days, so we generate a lot of various passwords. So there is always a temptation to write down your password on a small sheet of paper and to hide it somewhere close from your workstation, for example. But this is an absolute don't do, because this is what puts the security of your password and related information under threat, under heavy threat. Speaking of network security, many of us have wireless networks at home, and many of us use public networks. It is very convenient, but not very good from the security standpoint. Fortunately, this problem has been almost fully resolved in courts in Ukraine. And finally, it is necessary to secure one's remote workplace. So it is not advisable to leave one's working laptop at home or to leave it somewhere unattended especially in a public place. And if you work using your workstation, portable workstation somewhere outside court premises, please make sure that nobody is observing your screen. Thank you very much for your attention. Should you have any questions, I'm at your disposal.
Thank you very much, Mrs. Ushenko, for explaining us so clearly the threats that the use of IT itself can entail through phishing, hacking, emails, even video conferencing, and other always changing and self-generating attacks. It's been very useful. Please, Mr. Valery Vakal, Senior National Expert, E-Justice component of the EU project Pravo-Justice. The floor is yours, sir.
Добрий день, колеги. Основне, дякую Сергію Петровичу, дякую Сергію Сущенку за таку.
Good afternoon, dear colleagues. I'm grateful to my immediate colleagues, technicians, those who understand well the technical part of modern technologies, Mr. Sergei Suchenko and Mr. Sergei Chornutsky. So I would want to inform you that digitalization is priority in Ukraine these days, in particular in the field of administration, in the field of judiciary. This is why we conduct very close joint work together with the representatives of judiciary, members of parliaments, and legislation regarding UJITS, Unified Judicial Information and Telecommunication System. The UJITS will soon be deployed and will hopefully be soon deployed across the judicial system, and the matter of security will be important part of testing new functions of the system. We will also make efforts to increase the information and telecommunication proficiency of users within the judicial system, because such situations where a password is written on a sheet of paper and put somewhere not far from the workstation should be unacceptable. So what I wanted to say is that we are now planning the module which would allow exchange of emails in a secure manner. So this is what I wanted to share with you. Should you have any questions, I'm here to answer.
Thank you very much, Mr. Vakal, for stressing the importance of security in order to deal with information through IT. Now we will have time for questions in English and Ukrainian received by the chat box. So please feel comfortable. I'll kindly request Mr. Shaban's assistance in case we receive questions in Ukrainian. We haven't received any so far. Please, Mr. Chavan, seen your name there.
Yes, Mr. Palma, I just want to inform you that there is no question in chat, so maybe
Please.
our participants,
Absolutely, please.
you can raise your hand and ask questions to our speakers.
Good. I must say that all the presentations have been eminently clear. I don't know if we are receiving any other one in other language than English, so please feel comfortable. In the meanwhile, I want to thank you so much for all your outstanding presentations that pictured so vividly how the Ukrainian people are doing their best to provide justice and fight threats and targeted destruction under the terrible aggression that they are suffering. The whole session has been deeply moving for me, and I think for many of us, and I salute your courage and admirable effort to move on. I think it's been pretty much about it. I've seen the salutes and the thank you messages, so I'm going to thank you to all of you for being such a fantastic and dynamic audience too, and we'll keep you posted about the date and time of our next online conference of the program. Soon we'll post in the IACA website the link to access to the conference recording and to the materials that have been provided already by Ms. Bashina. Please stay tuned. Looking forward to meeting with you soon again. Thank you so much and have a great day.
Дякуємо.